Alright guys, buckle up because Eric Martin is back in court, back in jail, and somehow still convinced he's the smartest guy in the room. Despite a prior offer of a PR bond, he stayed locked up because he couldn't stop talking. Today, his public defender argues he's basically served his time already. But Eric interrupts, objects to common sense conditions like avoiding the victim's house, and rants about due process violations. The judge warns him clearly, but Eric won't let up. Even after winning the motion, he keeps running his mouth. It's not just self-sabotage, it's a full-blown commitment to failure.
Good afternoon, Your Honor. Don Silva on behalf of the people, PA 7439.
Nicholas Darren on behalf of the defendant, Mr. Martin, who appears before us via Zoom. Mr. Martin, if you could unmute yourself, state your name for the record.
Okay, I got it.
You got it.
All right, you hear me?
Yep.
Alright, so this is People versus Martin.
Yes, Your Honor. I have spoken with the complaining witness at the time. He would like to proceed with this case, and the people would ask to set it for a settlement conference before we go forward with trial to see if there's a resolution.
Alright, and Mr. Darren,
I mean, Your Honor, I guess we're gonna proceed that way. I was hoping, I'll renew my motion from the last time. Mr. Martin's been incarcerated, I think it's like 62, 63 days now. Court rule is pretty clear. If he's in over 28 days, he should be released on a personal bond. Mr. Martin's just been sitting in jail on this matter. I mean, I guess from practical, I would imagine the court's gonna give him credit for time served, regardless of what the resolution is on this matter, considering he's done over, at this point, he's done over two-thirds of what his original sentence would be. We're not going to accept an offer on this, and I guess we'll just set it for a settlement conference then, if that's what sister counsel wants.
And Your Honor, it's I know this case has been going on for a while.
personal bonds.
That's correct. The issue here is that him and the victim are brothers. They live at their family.
First I want to deal with the whole bond thing, because
Yes.
his bond is $2,500 personal.
So I think the issue with that is I was having a cover last week, but per the notes, if you recall, you ordered him not to return back to the property because there's a no contact order in place. 2 weeks ago, when Mr. Brother Counsel appeared for the first time on this case, I believe I agree, and that's when the bond was changed. But Mr.
Who changed
Martin,
the bond?
Judge Kirsten, yes.
So, Your Honor, Judge Kirsten changed his bond, and then after some further statements were made, he changed his ruling to leave Mr. Martin in jail.
And that's because Mr. Martin made comments about returning back to the location, the home where the victim lives. And to my knowledge, per my conversation with Mr. Martin, the victim today, he indicated he'll be leaving the hospital, returning to that house tomorrow.
Right, all right, so I'm going to
I mean, I have no objection.
Mr. Martin, now listen, you understand, I wasn't here, but Judge Kirsten, your original bond was $2,500 personal. Then he set it at $2,000 cash because of the alleged violation that says it says need to set a hearing on violation ASAP. I don't know if there was I don't see anything on whether there was an alleged violation of the bond condition. Is that right?
Not an alleged violation. He made comments.
He made a comment about it.
That he'll return back to the house.
This is why something. All right, so you understand you can't go to that house while you're on that. That's while the bond's in place. You understand that? Stay somewhere else. You understand that?
No, I do not understand, and I gotta stand up. First, I have nowhere else to go. Okay, so that's why I must return back there, and I objected.
Here comes Amber McHenry, diving headfirst into sovereign delusion. After missing her last hearing, the judge calmly cites the warrant issued for her arrest. McHenry. She fires off a flurry of sovereign buzzwords. Wrong CASA number and appearance rejected. and demands everyone's oaths and bonds. When that fails, she starts accusing the court of kidnapping and demanding the accounting. The judge is unfazed and orders her into custody. Her screeches echo as she's let out. The original issue: a $300 fine, but thanks to her nonsense, she just escalated it into a criminal case. Brilliant move, Karen.
I objected to the bond conditions before, I'm objecting to them now.
Listen, your objection is duly noted. You have very, very highly competent counsel. So, let's let your counsel, speak on your behalf. And so he already did. He made a motion.
I object to you speaking on behalf of that.
Stop interrupting me, sir. I'll just hold you in contempt of court for 90 days and then you can just sit there anyway for it. Stop interrupting. Your Mr. Madera made a motion to set this for a personal bond. I'm going to set your bond at $2,500 personal. No contact with the victim or the victim's home location. And if you show up at that location and violate my bond, you can be held in contempt of court. Just want to make sure you understand that. I'm just telling you that right now. So I'm setting your bond at $2,500. I'm granting the defendant attorney's motion. And the bond's $2,500 personal. No contact with the victim. And no live in the state of Michigan without the consent of the court.
I got something to say.
And you have a right to remain silent, and anything you say can be used against you, and you already have an attorney who's talking on your behalf, and I've already granted his motion and changed the bond to personal, so.
Hey, well, I have something to say in response to that.
See everybody at trial.
I have something to say in response.
We'll see everybody at trial. Mr. Darren, do you have anything else further?
Your Honor, are we going to set it for a settlement conference, or are we just going to set it straight for a trial?
Sure, I'll set it for a settlement conference, and then a week later it'll be the trial.
All right. Your Honor, I understand the court's position. I mean, if Mr. Martin wishes to make a statement on his behalf, I can only advise him that I wouldn't. But if Mr. Martin wishes to make a statement and the court wishes to hear it, I don't have any. I mean, I'm not going to. I'm advising him not to say anything, but Mr. Martin, if the judge wants to hear it, if he's allowing it, then I'll step aside and let you stay.
Mr. Martin, I've already granted your attorney's motion to set the bond at $2,500 personal. So if you have some other statement you want to make, I'm just going to reassure you again that you have the right to remain silent. Plus, your attorney's already said that, hey, you know what, it's probably a good idea to just do so. But go ahead.
Yes. Like I said, I'm going to exercise my First Amendment right to speak, and I have a lot to say, so I ask that you don't cut me off or I'm done talking now. I object to the bond conditions and stuff. I can't be in my house. It violates my due process rights. I have nowhere else to go, and he's not the true victim. He's lying, saying he's a victim, but I told the cops when they arrested me that I was the victim. And so we have an equal protection clause violation.
All of that will be the subject of the trial itself, so. We'll hear everything you have to say about that at trial. Your objections duly noted. But it doesn't change my positions.
Now this one's next level ridiculous. A Texas homeowner returns to his property only to find it occupied by a sovereign squatter. The squatter insists he owns it because he sent an affidavit and no one responded. So, obviously, it stands as truth. The court, however, doesn't operate on imaginary logic. The only problem? Homeowner didn't properly serve the eviction notice, so the judge dismisses the case. The squatter says he's already moved out, but plans to reclaim the house after the reset. That's right. His legal plan hinges on a conspiracy fantasy. At least he left without a fight.
Take a seat.
I have a question.
In this blue chair.
Do I have
Sit down.
Do I have the same rights?
You want me to hold you in contempt? Sit down. In that blue chair.
Do I have the
Sit down.
rights there?
One more time. Sit down. You are charged with one count of no operator's license, a minor misdemeanor subject to a maximum fine of $150 plus court costs. You also are charged with one count of expired plates, also a minor misdemeanor subject to a maximum fine of $150 in court costs.
I am the authorized agent to the decedent estate. I am coming in here as the settler, and I want to settle this case.
I will enter no plea on your behalf to these charges. I've given you 3 plea options to plead.
No,
Would you
I do not recognize anyone in this court.
Okay, well,
I
that's
don't
too
recognize
bad.
you or the bailiff or anybody else in this court. Then I'm just going to surrender the person to the court because I'm not coming back.
I don't know what that means.
You do know what that means.
I don't know what that means.
I am not the ens legis, non de guerre.
I've been practicing law for 36 years, and what you've just said to me has no meaning to me whatsoever. So let me say it one last time, because we have other cases to handle today. If you don't leave the courtroom and go to the clerk's window and get a trial date, which is what I'm scheduling in this case, I will hold you in contempt of court and I'll have you arrested. You either go to the clerk's window now and get a trial date, or I'll have you taken into custody now. The court is now on the record in City of Conneaut versus Amber McHenry, 24 TRD 819. Ms. McHenry entered no plea to charges of no operator's license and expired plates, each of which is a minor misdemeanor, on December 17th, 2024. I scheduled it for a bench trial for January 8th of 2025. Ms. McHenry was given notice of that bench trial. I have a signed receipt in the file showing she got notice of that bench trial. Present on January 8th, 2025 was the law director along with a police officer. Ms. McHenry failed to appear. As a result of her failure to appear, I issued a warrant for her arrest. That was January 8th. It's now over a month later, February 11th, and Ms. McHenry is now turning herself in on the warrant. She's in the courtroom, and she is without an attorney. Ms. McHenry, why were you not here on January 8th of 2025?
I have a question about the case.
Ms. McHenry, sit down. This is not your courtroom. Sit in that chair.
I have a question about the case. That's not the case number that I had.
Yes, it is, Ms. McHenry. You've got other cases pending that are set for jury trial.
The original case number that I had was like TDR, like 0800 something. And
24 TRD 819.
819, okay. I was just double checking on the case number. Can you repeat your question then? No.
Why were you not here on January 8th?
I put in an appearance and it was rejected and struck from the record, and I was sent a letter saying that I am not who I said I was. So I have a question about that because I don't understand.
This is not a discussion here. This is not a conversation. I ask a question, you respond to my question. Now, this is typical behavior for you because you're a sovereign citizen. At least you claim to be.
Enter Judge Haywardand Leigh McThomas, who claims he's not the man, but the trust. He rejects legal representation, citing YouTube pseudo-law about jurisdiction, capitalization, and copyrighted names. But Judge Hayward is the real deal. With a calm smile and razor-sharp logic, she tears apart his nonsense. She compares his legal theories to refusing medical help after a gunshot wound because you Googled how to treat it. The gallery laughs, but she's deadly serious. Her courtroom isn't here to entertain TikTok theories. It's here for justice, and this judge delivers it with style and substance.
Your documentation that you file, including the one you filed today that did not have a correct caption or case number on it, is indicative of that. So let me ask you, Ms. McHenry, again, why were you not physically, personally present in the courtroom on January 8th, 2025 for your trial?
I need the oath and bonds to be put for each person acting as a public official in this case who is acting as a public servant to be put on the record. And I also require the indemnity bond, and I'm going to require the other bonds. I need the accounting. Please, for the record, let it be known that you exited.
I
while
did.
asking.
I exited the courtroom and asked a police officer and
Who
probation
has
officer.
the indemnity bond? Where is the bill of particulars?
The
Because I
bond is
did not receive
being,
it.
the warrant is being executed, you're being taken into custody, take her down to the jail now.
I was not given the warrant.
Take her down to
either.
the jail now.
Why am I being arrested?
Take her down
For
to the
what?
jail.
What crime have I committed? Get off me. This is kidnapping. This is a false arrest.
Stop it.
No, this is a false arrest.
Okay, relax.
This is kidnapping. They're violating my rights, my constitutional rights. I put in,
I thought the Constitution didn't apply to you.
the Constitution applies to every living man and woman.
Yeah.
You are violating your oath, Mr. Iarochi.
Lamech doubles down with Sovereign. Gibberish maritime law, UCC codes, and imaginary courts in Texas. Judge Hayward doesn't blink. She hits back with clarity and humor, reminding him that courtroom procedures aren't optional and the law isn't fan fiction. Her punchline: try replacing a doctor next time you're sick. The courtroom chuckles, but her tone stays firm. This isn't her first Sovereign rodeo, and it shows. She refuses to let Sovereign nonsense derail the proceedings. It's part comedy, part education, and 100% a lesson in why real judges don't play Sovereign games.
Frederick Falcon versus James Larry Warnke.
Give this to the judge, sir.
Mr. Falcon, this is your case. So what is it you're asking for the court?
We purchased the house through tax deed auction, and we're just asking occupants to vacate the property.
A tax foreclosure sale?
Yes, sir.
Okay, I see a copy of your sheriff's deed. You had it attached to the petition, and you purchased this on the first Tuesday of November, is that correct?
Yes, sir.
Okay, and after you purchased the property, I guess you realized it was occupied, and you served a notice to vacate. It says hand delivered.
Just let us know.
And by hand delivered, do you mean you actually handed it to him?
We tried to. There's a lot of signage up at the property. It's very intimidating. Gun, don't trespass, knocked on the door, left the letter.
Where did you leave it?
Front door.
It says hand delivered.
Yes, sir.
Okay, but you didn't hand it to anyone,
No one refused to answer.
sir?
No one answered. No
No
one
one
answered.
answered. So you just stuck the notice on the outside of the
Stuck
door,
in the door.
in the door, not on the inside of the
Through the crack.
through the
Went
crack.
in the house. Went in the house.
Okay, let me hear from you.
I never did see it,
Okay, but
but
what's your opposition to this eviction?
I've got an unrebutted affidavit I sent to the Albert Uresti tax assessor around 2021. He didn't rebut it. So an unrebutted affidavit, as far as I know, it's a maxim of law. It stands as the truth of the matter. The truth of the matter is I don't know property taxes because I declared my house private property.
Now Judge Hayward lays it out. Lamech is charged with obstruction, no license, and suspended license, all with real penalties. Up to 12 months in jail. Thousands in fines. She walks him through the merger doctrine, possible plea combinations, and court procedures. Lamech hesitates, but eventually requests to plead no low to some and not guilty to others. The judge accepts and advises him to request discovery. Her tone is firm, but still professional. This is the reality check moment where sovereign fantasy collides with cold, hard law. And it's not looking good for Lamech.
And private property is not subject to, only real estate is subject to income, property taxes. So that's what I couldn't understand, how they just went around an unrebutted affidavit like it was nothing.
Okay, so what you have is an issue of title and I don't have authority to hear any issues of title. Okay? Not within my jurisdiction. You'd have to do that in a different courtroom. Okay? But for today's purposes, you got very lucky because the way you serve the notice to vacate doesn't comply with Texas law. You can't just stick it in the door. You have to put it on the inside of the main entry door. You have to look at Texas Property Code,
What do we do?
Section 24.
What if we do if he's not answering or not?
Well, that's what I'm telling you. Either hire an attorney or read Texas Property Code Section 24, and it's very specific as to how the notice has to be delivered. Now, the law is clear. It has to be delivered in certain ways, but it doesn't say they have to actually receive it. Okay?
Yes, sir.
Because I've had people say, I emailed it. Well, that didn't count under the law. You know, there's ways you have to serve it. And based on your testimony as to how you served it, it's not one of the legal ways to serve the notice to vacate.
Would I be able to serve the notice now?
Lamech tries. One final trick, claiming the court has no jurisdiction because the hearing is on Zoom. But Judge Hayward calmly shuts that down. She explains post-COVID virtual hearings are fully legal under Georgia law. No sovereign loophole, no man versus trust argument will stop this train. She locks in his plea date and trial. And with that, the courtroom circus ends. Lamech runs out of steam. The judge stays composed. It's checkmate. Fantasy law just got steamrolled by the real thing, and Judge Hayward never even raised her voice. It's a beautiful thing to witness.
This case is going to be dismissed because the notice to vacate was not properly served, and you're going to have to start over. And so I would suggest we speak with an attorney about your title issue, if that's going to be your.
I've got another unrebutted affidavit here called the Executor's Entitlement Land Title, where I own the land
Okay.
under that
Again,
house.
I cannot determine who owns the land. I can only determine who has the superior right to immediate possession. That's the only issue before this court.
Well, hey,
That's the only issue I can address.
let me stop all this then. Let me just give him the house. I've already vacated. I've got another place to live, and I just want to settle this. After the reset that's coming up, we're going to have a global reset. I'm going to get the house back because I own the land.
Okay.
I'm a sovereign principal. I'm not a U.S. citizen. U.S. citizens can't own land.
Yes.
On a deed, a Texas deed, it says they're a tenant in peaceful possession. A renter, I'm not a renter. I own the land. And I don't own the house. He supposedly does because they just went around and my affidavit like it didn't exist.
I have heard those arguments, sovereign citizen, multiple times.
No, sir. I didn't say sovereign citizen. I said a sovereign principal.
Sovereign
That's a big
principle.
difference.
Okay.
You thought it couldn't get worse. Then a sovereign parent shows up claiming their kids are actually corporate entities. Seriously, they argue that child support violates contract law because the children are property of the state. The judge listens patiently before firmly correcting every delusion. No, kids are not corporations. No, you don't need a consent contract to be a parent. And yes, child support is enforced by law. It's hard to watch someone weaponize sovereign fiction against their own children. This judge doesn't let the damage spread. Another delusion legally dismantled.
Through the Universal Will Court in Fort Worth, Texas, Judge Henderson, I can own land.
Okay. But those issues, I cannot hear those issues.
Okay.
This court
Well,
does not
can you
have
just give him the
jurisdiction.
house then?
So are we in judgment then if he's,
I can't give you a judgment because you didn't properly serve, but he's telling you he's surrendering the house. You give him the keys and that's official surrender of the house.
Okay.
Okay? And then you probably don't have to file anything. You don't have to come back. You're going to get your house.
I'm doing him a favor. I want to
You
be
are.
done with this.
Yes,
I'm going to get the house back.
This next one's unhinged. A sovereign detainee is brought in from lockup and immediately begins shouting about admiralty law, corporate courts, and being held without consent. He demands to know the contractual basis of his incarceration, ignores every question, and yells over the judge. It's chaos. The judge finally has enough and orders him returned to the holding cell case postponed until he can behave. It's a live demonstration of what happens when delusion meets due process. And spoiler, the court wins every time. You don't get to scream your way out of legal responsibility.
Lamech Thomas had an
Yes.
announcement to the court, I believe.
Yes, I would like that announcement. I was going to ask. Go ahead.
All right, so I won't be needing an attorney. I'll be representing myself as my trust. I'll be representing my trust. I wouldn't need an attorney.
Okay, what you mean by your trust?
I'm sorry.
What you mean by your trust?
My name is trademark copyright. Representing my trust when they have.
What does all that mean legally? Do you even understand what you're talking about?
Yes, ma'am. No jurisdiction. I'm not under
No, ma'am. No, sir, Mr.
Jurisdiction.
Mr. Thomas, no. No. We got a president with 37 felonies, sir. He was under somebody's jurisdiction. So I don't know how you, a black man born in America, thinks that you got some stuff that's going to keep you from being under somebody's jurisdiction. All this, I done trademark my name and it's I'm not the true man, and it's the paper man, and all that foolishness, Mr. None of that works. None of that works. Y'all go on the internet and figure out some stuff that don't make a bit of sense, and then it hampers you because you think you know better than an attorney who's gone to school for 3 years and 4 years before that to go to college, and they figured out, and then they worked. Mr. Lynch has been an attorney. I've known him for 10 years now, at least, right, Mr. Lynch? So, but you think
getting close.
you think you done gone online and found some stuff, and you the trust of the straw man of the sir. You don't even understand the American legal system and how it works, but you gonna make up your own stuff because somebody done told you that this works. Same person who told you it works, it don't work. Then what kills me is y'all do stuff like, oh, and under the UCC and the maritime, y'all start quoting stuff that doesn't mean anything. I had one guy in Atlanta tell me something was under maritime law. I was like, sir, we are not even near the ocean. Maritime law is for the ocean. It's the esoteric foolishness that y'all get because y'all have done your research. No professional. What you don't, you over here talking about you the trust. Okay, imagine if you walked into a hospital and they told you you needed surgery and you said, oh, no, I'm the trust. I'm not the man. I'm going to do my own surgery because I looked it up online.
I'm not the trust. I'm representing the trust.
No, mister, you don't even know what that means. What I'm saying to you is professionals work for years to learn this, to be able to represent people. You wouldn't walk into a hospital if you had a stab wound or a gunshot wound and say, oh, no, the trust is going to take care of me. I'm going to do it myself because I did some research. I am so sick of y'all thinking that attorneys don't do anything. My mama's an attorney, and one of her clients said to her, well, all you really do is, they're trying not to pay her. All you really do is talk. I can talk. Yeah, but do you know the right words in the right sequence and the right things to look up to make the talk you do make sense? No, you do not. So if you think you can replace a lawyer, go replace a doctor. Next time you get sick, go break an arm and go set it yourself. Go let the true man set it.
We end with a classic soft sit moment. A woman in court claiming she doesn't stand under the jurisdiction of the judge. She won't say her legal name, won't confirm her identity, and insists the court is invalid. The judge, unbothered, issues a default ruling. Soft-sit logic strikes again. Refusing to participate means forfeiting your case. It's the legal equivalent of plugging your ears and losing by default. These courtroom moments are funny, sure, but they're also cautionary tales.
So if you don't want Mr. Taylor to represent you, that's fine. You are free to represent yourself. I will give you the Ferrata warning as soon as possible. But what I'm telling you is there are problems that come with that because you may be hampered by the fact of what you don't know. The second thing is, don't expect that if it goes wrong for you, that you can then say, oh, well, I didn't have good assistance of counsel, because you are your own counsel and you've chosen that. And so just be clear, the third thing, I'm not going to listen to all this esoteric foolishness that you spouting off that you barely don't know. I'm going to follow the law that I studied and I've practiced for over, we rolling up on 30 years now. And so no, we're not doing this trust stuff, the true man, the UCC. We're not doing none of that. So when you come before me, I'm doing the law that I know it to be. I'm going to follow the statutes, the Constitution, and the case law before me that is good law in the state of Georgia and the United States. I'm not playing your game. So let me know. I want you to be clear that this is how this is going to go. We clear?
Yes, ma'am.
All right. So are you entering a not guilty plea and you intend to go to trial?
What are the charges? I wasn't read the charges when I came in here. I was skipped for some.
Yeah, actually you were, because you have traffic charges and then you have an obstruction charge. Case 2024CR02581, obstruction of an officer. That's the one where you've decided you do not want the assistance of an attorney. The next case is 2021CR04186, traffic violation, which is generally a red light violation. License driving on a suspended or revoked license, count 2. No license, count 3. One of those will merge, so you won't face both of those because of the merger doctrine. So either you would have, if you were convicted, you would face either the driving on suspended or revoked license or the no license, not both. But those are the charges that are currently pending for you.
Okay.
All right, you're entering a not guilty plea and you wish to have a trial?
And those are together, or are they two different charges? Are those two different charges, or that's one whole docket?
You have two different cases.
Right.
The traffic offenses are on the 2021 CR 04186. The obstruction of an officer is on 2024 CR 02581.
Okay, and what are the possible outcomes for these pleas?
Possible outcome is on a misdemeanor offense, if you're convicted, the maximum penalty could be up to 12 months in jail, a $5,000 fine, or both per offense. So for each of the offenses, but with merger doctrine, you would have 1, 2, 3 possible 12-month sentences.
And
those could be or fines. Those could be served concurrently, meaning at the same time, or consecutively, meaning that they would be one after the other. One ends, the other one would start.
All right, I did hear eligible for NOLO. I did hear that come about. So I'll see fit NOLO on the.
Okay, but Mr. Thomas, listen to me. If you're entering a plea of guilty or NOLO, we do a plea right now. If you're entering a plea of not guilty, that means you wish to have a trial at a later date. You can have a jury trial or a bench trial. If you want to do NOLO on your traffic offenses, that's fine. We can do that case now, and you can save the next case for a trial. But if you're entering a plea of NOLO and you want to do that on your traffic offenses, that's fine. We can do that now.
Yes, ma'am. I would like to enter NOLO traffic offenses and not guilty for the obstruction of officer. And by any chance, did that police report show up yet?
We're still pending on the police report, Your Honor.
Okay, so now that you're representing yourself, then you'll have to ask for the discovery and get that information through the Solicitor General's office. If you just write a note saying that you wish to have discovery on this case, then you drop that off at the office or mail it to them, and she'll give you all of the discovery so that you can be ready for trial. Okay?
So I go to the courthouse?
Yeah, you can do that. On the 3rd floor, the Solicitor General's office, and you want to give them a handwritten note. You don't have to type it up or nothing. You can handwrite it that says, I wish to have the discovery on case 2024 CR 02581. And then put your email address, your phone number, and your full address, and that way they can give it to you or tell you how best to get it.
Okay, and is there any way I could do that without showing up? Cause I don't live anywhere like in that area.
You can contact the Solicitor General's office. So you would Google Clayton County Solicitor General, Charles Brooks. And if you call their office, they'll tell you who to contact to get that done.
Yes, ma'am.
All right, Mr. Thomas, did you wish to do the traffic court now? The traffic offenses now?
I believe so. Yes, ma'am.
All right, so raise your right hand for me.
I'm not in the jurisdiction of a courthouse, ma'am.
Okay, the law has changed, which when under COVID, which allowed us to do hearings by video. So as long as you are on video with me in the virtual courtroom, you're under the jurisdiction and we can do the plea. Did you wish to continue?
No, ma'am, because I'm not under the jurisdiction. I'm in the video because I don't really know how to work this.